Good morning, everyone. I hope Canadians out there are staying warm because it's freaking freezing in Canada. It's been minus 46 on the weekend. For those of you who don't know, that's very, very, very cold. And this morning is a balmy minus 21. So it's been interesting to say the least in the last week trying to stay warm. So I feel for all the Canadians out there. But hello, everyone. Welcome to everyone from around the world. I was reading in the comments people from Montreal and Europe and Montana, everywhere. So today, what we're going to do is we're going to hang out and we're going to watch the hearing with Chad Pryor and Judge Boyce in the Chad Daybell case. So, if you saw my video the other day or heard the news, you know that John Pryor has filed a motion to withdraw from the case. And it is a death penalty case, which means Chad Daybell needs lawyers who are death penalty certified. Now, this morning, before we get into the court hearing, hello, everyone. Before we get into the court hearing, which is supposed to be at 10 a.m., but in our experience, it never really starts on time, but we will watch for it at that 10 a.m. Usually they're about 15 minutes late with the Daybell case. But so in the next 15 minutes, we'll talk about what went on the other day with the motion to withdraw. Also, I saw that there was an objection filed yesterday, so we'll go through that as well, and then we'll watch the hearing together and we'll see what happens with John Pryor. In the comments, it was funny because I was going through the comments and everybody's going, oh, thank God I don't have to listen to John Pryor anymore. And then at the same time, you kind of miss it a little bit if that's the case, because I was dreading the 8 to 12 weeks or whatever it would have been for Chad's trial with John Pryor. But then again, it's like, well, it's a little bit of entertainment factor as well, because, John can just go on and on and on and on. So welcome, everybody. England is in the house, Boston, Arizona. Hello, California, sunny California. You're lucky, guys. Minus 46 is so not fun. It is terrible. But it was humorous if you had to watch me try and find the plug to my car so that I could plug it in. I bought the cord, plugged it in, and it didn't reach the front of my place, so I had to go around back, and I had to actually fish the plug out with silicone barbecue tongs. So it was interesting. I should have recorded it because you guys could have had some fun watching a crazy Canadian trying to plug in her car at minus 46 is not fun. Welcome, everybody. Barb Murray says, did Chad Chin's Daybell run out of his wife's money? Yes, he did. He is deemed indigent. He can't pay for his lawyer. So, yeah. Now, let's go into, we'll talk about a bit about the motion, I guess, to withdraw. So, and thank you so much, Barb. I meant to say thank you for the super chat. I appreciate it. So, John Pryor files this motion to withdraw. Chad, because it's a death penalty case, he needs lawyers who are death penalty certified to do this trial. So there's two reasons that John says. Number one, Chad is indigent. He can't pay for it. I don't want to work for free. Now, John has been on this case for 3 years. It'll be 3 years in May, because he was in May of 2021. And that's the same time that Chad sold his house to John. So John owns Chad Daybell's house. Now, I said in my video the other day, I wonder if or when John gets off the case, that he will wait for trial to sell it. I'm curious about that. Let me know what you guys think in there. Now, that's one of the reasons. And then the other reason is to find counsel. So John said he's actively trying to find a guy, and he found a guy who is going to get death penalty qualified. Now, I would love to have a lawyer on my show. Maybe I'll do that. If you guys want another guest and start doing some guests, have a lawyer on the show and we can chit chat about it. You can let me know below who you'd like to see on, and then maybe I could make that happen if they want to, and we could chat about it. Okay, we have 10 minutes left, so I'm just watching. So now let's go to this motion to withdraw. So I'm going to be reading this out aloud, and sorry, the objection. We're going to read the objection because this just came in, and we'll read it together. It says, comes now John Pryor, counsel for the defendant, hereby responds and objects to the state's motion to amend indictment as follows. Number one, the state has not provided the defense with a copy of the proposed amended indictment. The defense has requested from the state a copy of the proposed language in a proposed indictment. As of the date of this filing, the defense has not been provided the copy. The defense cannot agree or stipulate to any amendment without first reviewing said proposed amendment indictment to ensure that all of the proposed changes are stated and no further changes are made other than those as represented. Okay. Number two, the state is attempting to change not only the crime charged against the defendant, but contrary to their assertion, prosecute under a different provision and under a different burden other than what was presented to the grand jury. What is going on? Number three, the defendant objects to the state amending the indictment regarding the alleged conspirators and is only engaging in semantics to lessen their burden other than how it was presented to the grand jury. Number four, defendant reserves the right to provide further argument at the hearing on this matter and make additional objections so as to reserve their right to object until such time as a hearing is heard on the state's motion. In the event the proposed copy is not provided in an acceptable time prior to hearing, the this is not even it. Okay, guys, I'm sorry. This is November 17th. So how did I get that? Pray tell. This is the wrong thing. I was like, what are they talking about? Okay, never mind. Never mind. Mama screwed up. Okay, I was like, what the hell is going on? Doesn't have, I don't know what's going on. Okay. Oops. Let's retract that statement and find the right one. Okay, Chad Daybell objection. Wow, that was not fun. Okay, let's go to the right one here. 13 hours ago. An objection has been filed in regard to Chad Daybell's attorney, John Pryor, filing a motion to withdraw from the case. That makes sense. But all it says is John Pryor filed a motion earlier this month to withdraw as Daybell's attorney, claiming that Daybell no longer has the ability to pay after being declared indigent in January 2023. Pryor has been Daybell's attorney since 2021. Chad faces the death penalty for the upcoming trial, which almost certainly will face complications with his attorney stepping aside after representing him for nearly 2.5 years. Pryor states in the motion that since this is a death penalty trial, it is akin to preparing for 2 trials. For the state's part, there are 5 attorneys from 2 county offices, including an out-of-state attorney who specializes in similar complex trials. Pryor says that at this point, he has worked for nearly a year to find a suitable replacement without success and would have to work for nearly 4 more months around the clock without pay if he stays on through the trial. Okay, so and then the hearing's set for 10 o'clock this morning. So it doesn't say what the objection is other than obviously there's an objection and it doesn't give the details. We don't see the motion or anything like that. So I guess we'll see what happens this morning in court. If you guys have a better link that you found, you can feel free to put it in there. It should work. Let's see if I can find another one. Usually East Idaho News would have it too, but I don't know if they have. It just says that an objection has been filed. So last I knew that Emma was renting in there, but that would have been a while ago. I don't know if she's still in there. If you guys know that, let me know. But that's what I heard. Good morning, everyone. We are going to, hopefully, it's going to start in 5 minutes. Yeah, Mr. Pryor has a shady past. I did talk about it a couple years ago, but I thought it would be fitting to add into the video the other day where John Pryor got in trouble back in 2012 for attempting to SA a woman. And she went and told on him, went to the police, and they were going to go get it settled in court. And he settled before the judge could settle it. He basically claimed guilty and got in trouble and went to serve 120 days in jail for it. So there's two sides to the story. One says that she, the the woman came into the office asking for help and advice on a child custody case, and she needed a job for employment. And he's saying that she came in and he offered her money in exchange for an activity. And she said, no, that's not what happened. So they went to court and he got in trouble. And that was in 2012. And if you guys check out my video on it that I did the other day. And that was that one thing. And then the other issue was the house as well that I had brought up. So kind of a mixture of information about John Pryor. One of the things that I always remember about John is in the preliminary hearing where he stops himself and he goes, sorry, Judge, I thought I heard voices from the corner over there. We know that Chad and Lori always talk about, hearing voices and, all this stuff. So I thought that was funny. I think that was deliberate as well. But good question. I don't know how he still has his law license. I don't know the deal. It's interesting though. I can't find his case when you look it up. So that's interesting too. Barb Murray. That's funny. Yeah, remember that? That was so funny. He's like, "Oh, excuse me, Judge. I thought I heard some voices in the corner from over there." uh, so we have about 2 minutes to check in on it, but I can see it's not happening yet. So Tom Pryor was in the portal and heard an echo. This case, though, now if John gets off and these other guys come in, these other lawyers, which looks like it's going to happen, but we'll see what happens. It could be a long time before they do another trial. I'm wondering when it would be. I mean, even to go, I mean, that's a lot of work to go and dive into this. There's so many characters in it, there's so many things to know, right? I mean, I guess when you break it down to the nitty gritty, but at the same time, I thought we would be over by April. No more Chad Daybell. And now we got to do a bunch of different things. So, yeah, I don't know. I don't know. That's going to be a long time. And Lori's got pushed back too. So it'd be fall is what they're looking at. Who knows if that's going to happen? I was just hoping to get rid of it. Chad Daybell, done. April. And I'm sure the family is as well. So now let's see. We're just going to check in on here. Mr. Judge Boyce. Like I said, usually it doesn't happen at 10 a.m. I'll be surprised if they start on time, but you never know. Today could be a new day. This is ridiculous, Maureen. Absolutely. Never ending saga of these evil people. But you know what? Even though it's been 4 years now, 3.5 since they started, since Lori was arrested, almost 4. Um, what was I gonna say? There's still a lot there's still a lot to dive into, really. Not what they're presenting in trial, but the all the other little things that would be interesting to go dive down, a deep dive. So, hello everyone. Nice to see you. Thank you for joining. Bets on how long John Pryor talks or whines? Immediately. Immediately. Quite honestly, Judge, his famous line. I'm surprised he doesn't actually have a shirt that says that. Jean says the lawyer said Idaho law says Judge Boyce may not allow John Pryor to resign. He may have to stay on by law. I did read that there's a possibility of Judge Boyce saying, "Yeah, no, you're going to stay," but I don't know. Oh, Darby C, thank you so much. I see you there. See if it That's awesome. Thank you. Good morning, everybody. Okay, see, it's 10:01. We don't see it happening, but it might be about 10:15. He's usually about 15 minutes behind, but doesn't mean we won't keep checking. Thank you, Maureen. Thank you so much. I appreciate that. I try my best. I do. You'll see that I've been working hard and getting these videos out to you guys. I'm doing my best, but I love doing what I do. I really do. So I appreciate you guys. Without you guys, there wouldn't be me and there wouldn't be more videos. Let's hope. What do you guys think? Do you think Pryor's going to be off? Do you think Judge is going to say no? What do you think? Let me know. That's really sweet. Click a like there, you guys, for me. That'd be wonderful. Lets the algorithm know that hey, Linda's stuff is good stuff. It's a little bit different. I know my live streams are different than my regular videos, but I guess that's normal. But I do love live streaming. I love talking to you guys. It's one of my favorite things to do. Quite honestly, Judge. John, I swear in the beginning stages when he first got on, you could see Judge Boyce doing his best not to go, "Oh my god." I wonder if he goes home at night and just goes, "Oh, to hear John go on and on and on." Uh, it's tough. Thank you, T. Dalton, for your super sticker. Thank you so much. Kathy says, I think Pryor is playing a game. It could be. I saw a lot of those comments as well, that Pryor is playing a game and it's just another tactic. And he's been planning this from the beginning, as I read a lot of comments on my last video. Let's check in again. Sometimes I wonder if I have to keep refreshing this thing because he's not going yet. Lori says, John Pryor may be the whiniest people I've ever heard. Well, he does have a pattern. He does have a pattern, that guy. He has been a whiner. Like I said earlier, it feels like thank goodness he's going to be off, possibly, because it would have been a long, how many, 3 months or 2 or 3 months. They said it's going to be it's going to be longer than Lori's was for Chad's. And remember, Chad, there's going to be a lot of dirt on that, I think, because Lori's situation was a little bit different because she wasn't proven to, while she was away, right? So, and a lot of things. So I think Chad, because there was things found on a shovel and a pickaxe pertaining to Tylee, and it's Chad's yard and all this stuff, I think there's going to be a lot more dirt that comes out in his trial than Lori's. It'll be different, right? I don't know. This guy has dupers, in my opinion. I think he, watching him in the preliminary hearing, I think he gets satisfaction off hearing about these details. And I see him, was it this way? It was like this, like he was sitting beside John, and then the evidence came and he's looking like this and he wanted to see all the documents. I don't know. It's just, there's something about him that there's more to that for sure. Wonder how Red Pryor's face will go today. Yeah. Hi, Mimi. So good to see you. Thank you for being here. Sarah says, I cringe every time he says, well, quite honestly, Judge. For me, it's his soliloquies. He makes a point. Okay, make your point. But then he does the soliloquy for 10, 15 minutes when he could have said it in 2. Quite honestly, Judge. Mandy says, give Larry that darn shovel. Yes, Chad is always doing the side eye, trying to peek at the gory evidence. He's always, he leers. It's, yeah. I did a video on his preliminary about when they read the charges and stuff. And whenever I do those videos, people are quite spicy about it. But it's okay. Jason says, listen to him repeat himself over and over and over. Yeah, it goes on a little bit too long, right? Shirley says, Chad ran out of money. That's why Pryor wants to go. Well, Chad ran out of money, but I think he ran out a while ago, I would think, because it doesn't go far. I mean, I don't know what it costs in the United States and for an attorney like that, but just in general, even in family law, let's just say, you can spend like $300 to $500 an hour for a lawyer in Canada, and maybe on the cheap end 200, but I think that's even pushing it. So in 4 years, how much work and how many, I mean, John always has a motion to file, right? He always has a motion to file. So you just got to wonder how much and how it couldn't take him that far. Okay, here we go. So let's see.
The state is represented this morning by Rob Wood and Lindsay Blake, prosecutors for Madison and Fremont County. John Pryor is here with the defendant, Mr. Daybell, and the court scheduled on shortened time today's hearing after receiving a proposed motion to withdraw as counsel. That was filed on January 11th. There was a declaration supporting the motion also filed January 11th. Court reviewed those and determined that the motions originally filed under seal would be unsealed, and they were. The state then yesterday on the 17th of January filed a objection to the motion to withdraw. I'll also note that the court entered an order just this morning that unsealed the previously sealed order of the court as it related to a August 25th, 2023 order. And I've provided copies of that to counsel, but it does have some relevance to today's proceedings. So let me confirm that. Mr. Pryor, you would have already had a copy of that order, but from the state, Ms. Blake or Mr. Wood, did you receive the court's order unsealing the August 25th from last year order and a copy of that order?
Yes, Your Honor, they were provided to council today.
Okay, thank you. And they're doing construction right through the doorway here, so council could speak up probably into the microphones, unfortunately. Try to make the record as clear as we can here. Mr. Pryor, are you ready to proceed on your motion?
Yes, Your Honor.
All right, and who will be arguing on behalf for the state today?
I will, Your Honor.
Ms. Blake. All right, Mr. Pryor, then, as I mentioned, I've reviewed the motion. If you'd like to submit argument in support of the motion, you can do that at this time.
Judge, because of the microphone, may I have permission to remain seated?
You may, and if you just pull the microphone right up close there, Mr. Pryor, because of this noise from construction, that will be helpful.
And Judge, I was advised by your clerk that the microphones are doing quite well and that I should probably, and is my voice at this point acceptable, Madam Clerk, in terms of the tone? It's not washing out?
Yeah, it's fine. We're picking it up. Thank you.
Judge, I appreciate the court releasing the order from 8/25/23. The court's well aware ex parte that I filed in January of 2023, well over a year ago, a year and 7 days, a motion to seek additional counsel. And the court identified the fact that at this point, being privately retained, that Mr. Daybell may not be eligible for having additional attorneys represent him. And I'm relying on the court's interpretation of that statute. And Judge, what has transpired, and as a matter of procedural history, in middle to late of 2022, I started the process of seeking additional counsel. I believe that was probably about 2 years ago. I started seeking a year and a half ago, seeking the possibility of getting additional counsel aid me in this case when I realized the magnitude of the discovery. That process involved, Judge, going through the list of qualified attorneys on the Public Defense Commission list. I took the process of identifying all of those folks and then reaching out to all of them. And the ones I didn't speak to directly, I spoke through the various public defenders, the people who ran the public defender's office. I went through that list and at that point was unable to find anybody that was available to do this. And it's no secret, it's reasonable common knowledge that the Public Defense Commission is having a difficult time finding death qualified attorneys to represent in these kind of cases. I then contacted the commission on a couple of occasions and spoke to their one of their assistants and their directors and got the idea of maybe reaching out to out-of-state attorneys and did the process of contacting about 6 out-of-state attorneys to see if that was a possibility as well. And again, with no luck. Shortly thereafter, I went through again and went through the same process, looking through the list of qualified attorneys. In January of 2023, about a year ago, I reached out to the court and said, listen, it's going to require additional counsel. Mr. Daybell is indigent. He doesn't have the ability or financial ability to hire another private counsel at this point. And the court went through its analysis and thus came up with the order that you released today, Judge. What has transpired, Judge, is that approximately in Judge, I don't want to misstate, so I want to be very careful about this, but I believe it was in October of last year, I reached out to a private attorney that I know and asked him if he would consider becoming death penalty qualified to aid me in this case, and he agreed to do that and started the process. He has been in relative contact with the Public Defense Commission, and at this point, up until today, when I spoke to him this morning, the holdup is the CLE, but that, you know, whether it's no fault of his or the Public Defense Commission, and I'm not putting any blame, but at this point, there's no appointment, there's no decision that has been made, and I'm really unclear because the commission won't tell me his status, only I can get relayed by what he's telling me. But it came to, I came to realize in late December that the amount of work that I'm going to need to perform before the trial was of such an extent that it would, in my opinion, create a situation where not all of the things that needed to be done for the trial commencing in April 1st could get done. This put me in a difficult situation. I want to relay to the court,
When you say December, what, December of this last year, 23?
December of 2023, Judge.
All right.
I realized at that point when there wasn't a decision about him being appointed, and the court obviously directed with its order that you'd be willing to compensate another attorney to help me. But in December, I contacted the attorney again. I was in relative frequent contact with him. And he said, listen, there hasn't been a decision. I said, please contact them, find out what the holdup is. Where are we on this thing? And since that time, it was more than weekly that I was communicating with him. Up to today, there still hasn't been a decision. I don't know what the status is, and there hasn't been an approval. At this point, this puts me in the situation where this court, I don't think, is obligated to appoint an attorney. Mr. Daybell has private counsel. And I want to state to the court that I don't desire to get off this case. I want to stay on this case, and regardless of Mr. Daybell's financial situation, I want to stay on this case. I could care less about the money. Mr. Daybell wants me to stay on this case.
Well, that's not really what your motion says, though, Mr. Pryor. Your motion says you want off the case because it's going to cost too much for you to work, the work it's going to take to get it through trial without compensation. So
Right, and that's correct, Judge.
this is an important issue for me today. Are you wanting to withdraw because you think you deserve to be paid for the work you do, which I understand? But when I'm considering the standards under Rule 44.1, which is discretionary under Part A, on a leave to withdraw, I may allow you to withdraw for good cause. And what I'm trying to determine is, do you want to withdraw because you're not being paid enough to continue through trial, or are you seeking to withdraw because you're simply not going to be prepared and ready for trial?
Judge, the situation is this, is that when I say to the court, and I'm saying that in all sincerity, I don't need to get paid for this case. The concern is this, is that at least at this perspective, Judge, I'm going to be doing this by myself. And it's going to expend a lot of resources and a lot of time that I'm not going to be able to commit to other projects or other situations. Now, obviously, I'm not taking on a lot of other obligations because of this case. Do I want to get paid? Everybody wants to get paid for what they do. Am I making that the only reason to withdraw? Well, it's twofold. Do I want to get paid for the work that I've done in this case? I do. I'd like to get compensated for the next 2.5 months and for the 2 months of the trial. And I do want to get paid, and I think it's fair. And Mr. Daybell and I had a discussion about this. Mr. Daybell expressed to me that he doesn't feel comfortable me continuing in this case if I'm not getting compensated for the work. And I advised him and told him that I don't need to get paid. I'm willing to do that. So if I'm not being clear, Judge, I'm willing to do it. Do I want to get paid and do I want to get compensated for this case? Yes. Do I think it's fair that I'm not getting compensated? I don't think it's fair. But it's twofold, Judge. The only way that Mr. Daybell is going to be ordered, or the only way the court can order Mr. Daybell getting additional counsel is if I withdraw. And that's the only situation that would cause the court to say, all right, Mr. Pryor's granted leave to withdraw because he wants to be compensated. Mr. Pryor wants to be paid for the work that he needs to do for the next 4 months. And Mr. Daybell agrees with me that it's not fair that I work for the next 4 months without being compensated. If the court decides to deny the motion, I want to make it clear, Judge, that I'm prepared to go forward and push this case to the end regardless. And I'm committed to that. Do I think it's fair that I don't get paid? No. Do I want to get paid? I absolutely want to get paid for the work that I do. And that's, and if I was unclear in my my declaration, Judge, that's where I stand on this issue. But the only way for Mr. Daybell to get appointed 2 capital qualified attorneys And the only, and the purpose of getting capital qualified attorneys, Judge, is when the government has to pay for attorneys, they get to dictate what qualifications you need to be a capital defense attorney. I chose not to go through that process and get capital qualified, even though the criteria that they've established, I qualify. But at this point, I don't see any choice if I don't get assistance from another attorney to help me in this case. I don't have any choice but to withdraw. The primary reason is that there is no mechanism that I can see based on the court's interpretation of the statute that allows Mr. Daybell to get assistance mandated by this court unless I withdraw. But let me be clear. Do I want to get paid for the work that I'm going to do? I absolutely want to. And does Mr. Daybell want me to get paid? He does. Does he think it's fair? He does not think it's fair, and he wants me to be compensated. And that's where I stand on this. If the court decides that they're going to deny the motion and say, no, Mr. Pryor, I'm not going to let you off. I'm not going to harbor any hard feelings. I'm not going to harbor any dislike for Mr. Daybell. I'm going to go forward and I'm going to do the best I can. And I'm going to make an effort to try to find someone to help me, even if it's the day before trial. But again, let me be clear. Do I want to get compensated? Yes, Judge. Do I think this is fair? No. But by the same token, primarily, Judge, is the only mechanism I can think of to allow Mr. Daybell to get two capital qualified attorneys to help him with this case is if I step away and withdraw from this case.
Prior, going back to your preparation for trial, of course, this is a capital case, and if there's a conviction in the case, then under Idaho Code 192515, there's a special sentencing proceeding. And Idaho has adopted ABA standards for capital defense cases, and generally that requires, for example, the appointment of a mitigation specialist for the defense team as part of those proceedings. And I'm not asking you to reveal any defense strategy or even list a name, but the concerns I have here is you say you'll go through and do the trial, but I really want to know, are you really ready for this trial? For example, do you have a mitigation specialist that would be prepared in the event of a conviction in this trial?
Judge, if the court wants to have an answer to that question, at this point, I'd like to take a recess, close the proceedings, and disclose that issue because that is a trial issue and it's a trial strategy that at this point, I am not prepared to make an open statement on live TV about what my strategy is. If the court wants to take a recess, go in chambers, I'd be happy to discuss where I stand on this. In terms of the ABA standards, Judge, in terms of complying with the ABA standards, I'm aware of those standards. I'm aware of what that obligation is. But again, in terms of how I'm going to proceed in that manner, I would prefer to do that in either in chambers or in a closed proceeding.
Okay, and I think that's a fair enough request. Again, I'm not asking you to reveal trial strategy or publicly put that out, but these are legitimate concerns I have in weighing out whether or not Mr. Daybell is going to receive effective assistance of counsel in this case if you are permitted to remain on by me denying this motion. So I do want to get into that issue and discuss that. The state's entitled to know the answers to that as part of their objection to this motion. In lieu of doing that in chambers or off the record, it's got to be on the record. It needs to be in a sealed closed portion of the hearing. I'll determine under ICAR 32. And I think really the best way to do that, unfortunately, at the inconvenience of those in attendance here, is likely to clear the courtroom and allow that discussion to take place with only those necessary personnel in here to conduct the proceedings as part of a sealed closed hearing. So that's what I'll do at this point to go through those issues, and then we'll come back on in a public proceeding. So I would request that courthouse security and the bailiffs, if we could have everyone step out except for the clerk and the necessary security while Mr. Daybell is here. We will close this portion of the proceedings, and also for the bailiffs, if you could just make sure no one's within earshot of the a doorway as well to make sure it's not carrying through on the microphones, and I appreciate your accommodating that. We'll also, of course, stop the proceedings from being live streamed, and then we will come back on the record once we're ready. We'll take a brief recess while that occurs.
All rise.
Okay, so let's just get back to this for a minute. I'm just gonna, well, we can watch that for a sec while I'm finding the information. So what's interesting to me is as soon as the judge asked, do you have a mitigation specialist? And he is saying, well, we need to go talk about this because I don't want to talk about my strategy. Well, when it comes to the rules of the death penalty qualified lawyers or in a death penalty case, the new rules came into effect in 2018 in regards to the defense team, and it needs to include at least 2 capital defenders, an investigator, a mitigation specialist, and at least 1 member qualified to identify mental or psychological disorders. So that's the criteria. So what I find interesting is he's just asking the question is like, okay, what I'm thinking is the judge is like, okay, well, you're looking for somebody who's trying to get death penalty qualified, right? What about the mitigation specialist? So it's just a simple like, yes, I did, or no, I didn't. So why do you have to go in chambers? Now, I don't know. I'm not a lawyer. So maybe there's another reason, but I just think how interesting that is that right away he's like, oh my God, well, obviously he probably doesn't have one. That has nothing to do with his strategy or whatever. I don't know. So that's interesting to me. And then what was he saying other than over and over? So he actually contradicts himself. And I love that Judge Boyce actually said, wait a minute, that's not what you said in your motion. So if we go back to the motion, he says, okay, counsel hereby moves to withdraw as counsel from this case. Since May 25th, 2021, undersigned counsel has represented Mr. Daybell in this case and the related previous case with the case number prior to that time. In that time, undersigned counsel has undertaken a sole counsel all matters of representation, including obtaining and reviewing discovery, conducting investigation, and hiring and working with numerous experts. Mr. Daybell retained undersigned counsel with personal funds. At a hearing on January 19th, 2023, so a year ago tomorrow, this court inquired of Mr. Daybell and declared him indigent. Mr. Daybell does not have the ability to pay for counsel's continued services, and Mr. Daybell seeks the appointment of 2 capital qualified attorneys to represent him in this matter. And as this court is aware, this case is both extraordinarily complex and the prosecution is seeking the death penalty, which requires counsel to essentially prepare for 2 trials. And then it says, see defendant's motion to continue the trial date to enforce Mr. Daybell's constitutional rights. Reflecting this complexity and the work required to prepare and try this case, this court has set aside 2 full months for a trial, and the prosecution team consists of no less than 5 attorneys from 2 county offices, including an out-of-state attorney hired at taxpayers' expense. Remaining on this case would require undersigned counsel to work around the clock more than full-time for more than 4 months without compensation and without the assistance of any other counsel. Hang on, I'm just going to double check if they're back or not. Nope. This motion is made with Mr. Daybell's full consent. Mr. Daybell has requested from me that he be given 2 capital qualified attorneys for his trial. I have made, which is interesting, okay? He's requested to get 2 capital qualified attorneys, of course, because it's death penalty certified. You have to have 2. I have made a diligent effort to find a lawyer to assist in this matter for a significant amount of time. But in court, he said, since October. That's 2 months, 3 months. The attorney who I located and agreed to try to get qualified has not yet been approved by the Public Defense Commission. The time for him to be of any assistance to me in preparing for this trial is long gone. Because Mr. Daybell is facing the death penalty and has been determined indigent, he is statutorily entitled to appointment of 2 counsel who are capital qualified at state expense. And then it says the Idaho State Public Defense Commission maintains a roster of capital qualified attorneys, which I looked it up, and there's 13 in Idaho. And some are going to, what's his pickle? Brian Koberger. While undersigned counsel could accept appointments to this case if it were non-capital, because Mr. Daybell is facing the death penalty, undersigned counsel cannot be appointed pursuant to statute. The counsel therefore moves to withdraw. Now, you see, once I read that, and then what he says in here, he's saying, like, no, I want to be on the case. Well, Boyce is like, no, you don't, because you said you want off it. And you're the one who withdrew from the case, right? So what he's saying in court, and I said this in comments, I don't know if you read this, and let me know what you think. But I find Mr. Pryor's demeanor today a lot different than what he normally is. Usually he's feisty. He's spicy in court. Today is not the case. It's very interesting. Interlocution, nice to see you. Thank you for still being here for this. This whole case is still a cluster. Yeah, you know what? Thanks for all you do. Thank you. Thanks for the super chat. Nice to see you. It's been a while. Yeah, so I see him being very different. Obviously, he repeated himself over and over. He said he identified lawyers to help. He asked for help. He's talked to public defender's office, he said, and 6 out-of-state attorneys. He said around October, there was a private attorney that would consider to get death penalty qualified and started the process. And then he quotes, "I don't desire to get off this case." Well, Boyce is like, take your pick, buddy. And he says, I don't need to get paid for this case. And Daybell's not comfortable if I'm not compensated. I don't think it's fair that I don't get paid. I should, but you've been doing that for how long? And if he declared Chad indigent a year ago, then you haven't been paid for a year. What's 3 more months? Unless, he just didn't prepare. I don't know. So this is a little bit crazy. Like buttons. Yeah, exactly. The judge called him out because it is. You file a motion to withdraw. His number one reason, said, Chad's indigent, so I want out. Number 2, he said, well, I have to get the death penalty qualified, which I understand that part, right? We understand that part. But it was no secret either, right? So I'm surprised. Pryor should have been, I don't know, maybe more ready. We saw him go to Lori's trial like every day, if not almost every day, and would watch the trial on his own, learn stuff. So what's going on? And I don't know, because I did the video the other day. I didn't dive into what it takes to get death penalty certified. I was trying to look that up, and it's time's a factor for me. So I was trying to look exactly what was up, but I saw that, it is a process. Well, if it's a process, then how come, could John Pryor, maybe you guys know, you can help me out. Could John Pryor get death penalty qualified, or how would that work? I got to figure that out. But yeah, he contradicted himself. And so now he looks like a little puppy with his tail between his legs, going, well, I really want to be on this case. I don't want to leave it. I don't need to get paid. And then the next breath, he's like, well, I want to get paid. Well, yeah, I understand you want to get paid, but you haven't been in a year. What's 12 more weeks or whatever it's going to be? I don't know. I mean, sell the house. Sell the house and you'll get paid. I don't know. Yeah, he's qualified. Okay, he says not. Well, who knows, right? We don't know what his reasoning is, this guy. This is interesting. DP removed is what Pryor's after. Maybe that's exactly it. He's crying wolf, I guess, and then saying, well, yeah, like I want on, keep me on, and then get rid of the death penalty. Could be. Barb says, what was the reasoning for Lori not having death penalty? They ended up taking it off. They said one of the reasons they stated was that they just didn't have the time to get death penalty or to get everything. They needed more time in order for it to be a death penalty case. And because Lori didn't waive her right to a speedy trial, because Chad did, she didn't. They were running out of time. So the judge says, well, okay, we're taking it off the table. That was one of the reasons. So Chad waived it. So I mean, sky's the limit for that dude, but we'll see. Laura says he's totally different because he has seen the public's reaction. He's full of it. But usually, even when he's full of it, he goes into like very feisty, but maybe he saw the video on his past. Sometimes I'm not so easy on them. But you know, these things need to be said. They need to be said. Bowmeister says, I think Johnny Poo has had a little drinky poo this morning. He made no sense. I don't want paid. I want paid. I want off the case. I want to stay off the case. Well, imagine being Judge Boyce, right? He's just like, well, okay, what do you want? Like, you filed the motion to withdraw. You stated the reasons. And now you're saying a different story. So what is it? Well, I want I want on the case. I don't. And Chad really wants me. He doesn't think it's fair. Oh, did he think it's fair that 2 children were buried in a pet cemetery and horrifically killed? And did he think it's fair that his wife lay in bed while he kills her? Allegedly. But you know, John should get paid for his services. Yeah, but he hasn't been for the last year. So what's changed? Honestly. What do you think? What do you think Rob Wood and Lindsay Blake are like, what is going on today? Like they have to deal with John quite often and they're like, what is going on? That's sweet. Yes, if you have a moment, please click the like button. That would be very much appreciated. Thanks for joining me today, you guys. We're going to wait to see. They're having a little bit of a sidebar. We'll see what happens about this mitigation specialist, which has to be part of it anyways. So let me ask you this. What's the difference between Judge Boyce saying, well, is there two death penalty qualified lawyers? And he just says, no, I'm looking for one, right? Oh, is there a mitigation specialist, which is part of the criteria? No, Your Honor, I don't want to talk about my strategy. We need to go on a sidebar. I don't know. Maybe I'm wrong, but it's just, I don't know. We'll see. Daz and Mika says, make him stay. I mean, John's had 3 years, almost, well, 2.5. Let's be fair to him, 2.5. And I don't know. That's a lot of information to know. Look at, I've done this for 4 years in videos itself, and still lots to go through. So I don't know how that's going to work. And imagine Judge Boyce going, "Oh my gosh, there's going to be 2 years if Pryor gets off the case." And I found it interesting as well when he was talking about in his motion to withdraw, and he was talking about him having help now. That time is long gone now. I don't know. I wonder what the conversation was like between John and Chad. Going, "Listen, this is what I'm going to try and do. We're going to do a last ditch effort to get you off the death penalty." I don't know. Maybe that's what it is. I'm going to see if I can get a lawyer on, you guys. We'll have a little chat with that. Larry says, Pryor said he was qualified under the Idaho standards for death case, but didn't apply. So why didn't he? Right? Why? I wonder. Maybe he has a little ace up his sleeve, like Letitia Stokes says, an ace in the hole. Why wasn't the prosecution keeping an eye on it? On what was happening with the death penalty, you mean? Barb, you're gonna have to just a little bit specify what you're talking about there, so I understand. I might have been, when I go through the comments, sometimes I'm a little behind, so I'm not sure what we're talking about at the time, but thank you. Yeah, Kathy, agree. Even his voice sounds different, the tone. Yeah, it was like a puppy, I think, kind of like a little wounded puppy sitting there. I don't know. Yeah, what do you want? Marilyn says, Judge Boyce is as confused as the rest of it. Yeah, he's just like, well, wait a minute. I love that he stopped him, though. I think maybe Judge Boyce might do a couple things different this trial, because Lori, I mean, she got to smirk the whole time. I still get a little upset about that because her behavior was disgusting in court, and it was never stopped, I guess you could say. But I love that he's probably like, okay, this is stupid. Judge is like, what are you talking about, John? You filed the motion. Word casserole. Yeah, I'm waiting for the Pryor temper tantrum as well. We'll see when he comes back now what his demeanor will be like. It's fascinating. Charlotte, I agree. He talked out of both sides of his mouth. I don't have to get paid. Well, I like to get paid. This is fair. This is not fair. I have talked about him throwing spaghetti at the wall quite a bit in the past couple of years. Well, I mean, he has to try, right? He has to try whatever he can. And John's filed so many motions over the years. And nice to see you, Karen Canada. Nice to see you. Rob looked like he was either going to push him or fall asleep. I think he looked like, well, I don't know. I only glanced at him once with Rob, but I think he's probably fuming anyways. I mean, having to deal with that. When was it? I think it was Rob Wood and Mark Means that they was an interesting dynamic between them. The more irritated Boyce gets, worse for Pryor. Yeah. Tess says if he didn't apply, maybe it's a ploy. I would love to have more about that. Like, tell me more, John, about that. Tell me more. Miss B says, let's be honest. If Chad was oh so innocent, all this wouldn't be happening. He knows he's going to be found guilty and he thinks he wants that off the table as per the extension, playing a game for sure. You know what's interesting? I find it interesting how in some cases, people don't get as angry in some cases as others, which is normal. But I was thinking about Chad Daybell versus Brian Koberger. And what's interesting in that is we don't have publicly information on Chad Daybell specifically that he killed anybody. Right? That's fair to say, right? And we don't in Brian Koberger. But what's interesting is I never hear people say, I think ever, that Chad Daybell is innocent. Never hear it. But I hear with Brian Koberger, a ton of people say that. So it's fascinating to me. In certain cases, it could be, I wouldn't say the same circumstance, but similarly circumstantial stuff. And people will go like bat crazy on the one and not the other. It's interesting. Okay, family attorneys 400 an hour. So in Canadian dollars, that's $520 or $550. Eduardo can help him. I'm surprised he didn't say yes, Your Honor. I contacted a guy named Eduardo with a G, and he's going to get death penalty certified sometime. Yeah, he's in the hall with Letitia's Eduardo. Oh, I love you guys. I could care less about the money. Wait, what? Yeah, didn't you say? Yeah. Barb says, keep an eye on Pryor not being death penalty certified. Oh, yeah. Yeah, I don't know. It's going to be interesting when it comes time, when they come back, they'll have a little chit chat about what's going on and they'll continue on and we'll see what the prosecution will say. We'll see what they say. Pryor is a book we could all read. Now, I mean, I understand he wants to get paid. I get it. But why are you complaining now when you haven't in the last year, right? I mean, or is it time where it's like, I can't anymore? But at the same time, he says, I really want to get it on. Well, stay on. Well, what is it then? What would you rather? Wonder what kind of soliloquy in the background is right now. They're all in a sidebar. They're chatting about it. And John Pryor is probably talking the entire time, saying the same thing. And Boyce is probably like, honestly, John, like, Mr. Pryor, what do you want? Figure it out and let me know in the next 30 seconds. And then John takes another half an hour to tell him what he wants. And Judge Boyce will be like, I asked you for 30 seconds, not a lifetime. And that's about it. Do you remember that? Do you guys know what case that's from? Is there yeah, it is hard to argue. That's for sure, but still it's hard to argue that well, I'll retract my statement because I don't, in all honesty, the public, I don't want this airing all over the public. Eduardo for president. Love you guys. I love to have little moments of joy and laughter because sometimes this stuff can get so heavy. Who delivered your coffee at -46? This is from yesterday, to be honest. But it was in the fridge, don't worry. And yeah, -40. It's not -46 today. It's -22. So -46 was with the wind chill. And let me tell you guys, the only time I went outside was when I had a hot flash. I had the hot flash. I was like, okay, now I could go outside and check because you have to check the vents that the heat comes out, all that stuff. You got to make sure it's not icing up because there could be carbon monoxide and all that other stuff. So you got to go out there and do that. And then the power grid, we had an emergency alert because it's like the power grid can't keep up, blah, blah, blah. You can only use your lights. So we had to turn everything off. And then at the same time, it's like, well, our power can go off and who knows, but it didn't because they borrowed some power from Saskatchewan. So I guess that's okay, but it's true. If you don't laugh, you cry. That's true. There's a lot of times I've had to make jokes. My muffler guy is gone though. Muffler guy's gone. I moved a year and a half ago, so mufflers guys no more. Yeah, a bit warmer. It's a bit warmer. Have you guys ever felt that? It is not fun. I don't even know how I live in Canada, to be honest. I should be on a tropical beach somewhere. Yeah, I've had to shovel. It's been interesting. It's interesting as a single woman having to shovel. And do all things, when sometimes you just kind of wish that there was a man to do it. I'm not gonna lie. uh, but I can do it. I did it. It's just not as fun. Yeah, it's so cold, but I stayed hibernated because it was 4 days of -46 with the wind chill. It just does not feel good. Come on, Pryor, finish it up, wrap it up. Well, okay, so I'll tell you a little as we're waiting for him, I'll tell you the timeout. So I went and bought a cord, okay? The longest cord was 32 feet. I figured that should be okay from the car to the house to plug it in. So I get home and I had to fish out the cord to the block heater from my car. And I didn't have the proper tools, so I went inside and I grabbed the tongs to the like silicone barbecue tongs. And I go out and I have to pull out the cord from the grill of my car, and I had the hood up. Guy drives by, he's like, "You want some help?" He thought I had to jump my car. I was like, "No, I'm just trying to fish out the cord." So he comes in, he has like a little hook and fished it out. Great, thank you so much. Plug it in. Now it doesn't reach the house. Now I'm like, you gotta be kidding me. I had to drive around back and then I had to shovel snow in the back, and it was icy and it was heavy. And so I'm trying to do that, and it's starting to get dark out. And then I finally got it plugged in. Oh, and one more thing, I couldn't get it unplugged from the front. Like after plugging it, I couldn't unplug it because it was too freaking cold. So I had to wrap it up, hold it in my hand with the door with the window down, and drive around back and hold the cord. I mean, really, I should have recorded it because you probably would have had a really joyful experience and a good laugh at to how ridiculous that was. But that was my last weekend. Yeah, wrap it up. We're all hungry, everybody. Like, hurry it up, John Pryor. This is one of the best comments of the day. I can't wait to order Chad's new prison book, Ukulele for Beginners. Can you imagine? Could you imagine the song behind it, knowing that we know Chad Daybell and his disgusting choice of words when he's trying to text Lori and be a man, and it sounds like a teenage boy, maybe even a tween? Oh, I'm screenshotting that. That's funny. That is funny. That's so funny. Oh. I got the giggles now. Kathy says you're right. You should have recorded it. I really should have. Yeah, time is money, Mr. Pryor. Can you please hurry along? You're doing it for free, so you better hurry it up. Kelsey says my laughter is infectious. It's just so funny. You know, when I was digging out the cord with the barbecue tongs, I was laughing that hard too, going, this is ridiculous. Like what I have to do. A guy drives up, he's like, oh, you need some help? You need a jump? No, I do not. I have to, this is me, like, as I'm crushing, I'm like, I have to fish out a cord. You want the barbecue tongs? Cynthia says, where's Mr. Linda? Mr. Linda, I split with him a year and a half ago. Almost, it'll be 2 years in June that I split with him. So we are still friends. But yeah, we are no longer married. I replaced the ring for the middle finger. Yes, they must be chatting up a storm out there in the sidebar. Chad's storm. I don't see court resuming yet. They are coming back. Weird. This is what I have. The Portal Potty Polka is his first ukulele album. This is good. See, you can have some laughs at It's a Crime. Sometimes I make little jabs at Lori and Chad because you just can't help it. I have to keep it light sometimes because I read murder all day. And by all day, like I'm going from 6 a.m. sometimes to midnight. So you have to have some laughs. Tall Flatlander says, strange how that works sometimes. My ex and I are now best friends. It's almost like I've never was even married. It was really weird, but we're okay. It's all good. And my son is adjusting well anyway, so we're good. It's all good. It just gets, a little lonely being single, but not that I can't do it on my own. Yeah, Carolyn says, I wish the judge was firmer with the lawyers. He comes across as very bland. I think he's very quiet a lot of times, and then there's like a breaking point with him. I was impressed on the sentencing hearing with Lori Daybell because he did give a mouthful to Lori about what he feels. So he did a great job for that. I commend him for that. But yeah, throughout there was a lot of leeway given, I think. But maybe now it's like, forget it. I'm not doing that anymore. Did I ask if the guy who was single helped you fish? No, he was married man, and it was okay. It was like a neighbor. It was all good. Sue says, "Hi, Sue. He's waiting to sell the house just in case it is worth more than he's owed at this point. He may have to share proceeds with Chad, so he will hold until the end." Well, I don't know. I don't think he would be sharing, but this is what I think he would sell. I think he would wait till trial. This is my thought. I said it in my video the other day. I think maybe he'd wait till trial to the height of it and then sell it. I don't know. That's just could be me. But there were some lawyers. If you saw my video, put yes, saw a video in the comments. But there was a couple of Idaho lawyers who talked about the whole house thing at Chad selling the house to John. And they said, in their opinion, that's not a good move and it is frowned upon. He did redeem himself at sentencing. Absolutely. Written by the storm. Yes, saw the video. What is a video? Okay, because I realize there's a lot of Chad Daybell and the Daybells on my channel. I get it. I thought I was dialing in to get April done, for Chad. Now, we might get a little break, depends on what they come back and say. But, sorry. What do you want to see? Do you want to see some of my theory videos? And I put some of those out, sprinkling, of course, not too much Daybell, because we got to get into some other cases. That's important. And I have a little request for you guys. When I do a full case, meaning something that you've never heard before, and I do a full video on it, I ask, pretty please, with cherry on top, for you guys to watch it so that I can break away from some of these other videos that just constantly, going, because I find that when I try and dive into other cases, sometimes people don't know, or they don't know that of me to do a full case. So I am dabbling in it. But what happens is, if no one watches it, then I can't break out, so to speak, and branch out. So the algorithm's like, they don't like it. So now I'm not going to show them this, and now I'm not going to show them that. And then, that kind of thing. So I just ask, if I do things like that, do check it out. Maybe you don't like it. That's okay. But at least try it. It's kind of like saying, oh, you don't like this food, then just try. We're getting back. But yeah, I would like to do a couple different things. So you'll see me tinker, but I always want to give you guys what you want.
Thank you. Please be seated.
Here we go. Let's see what he says.
All right, we're back on the record on case CR 22-21-16-23, State of Idaho versus Chad Guy Daybell. This is a hearing on defense counsel's motion to withdraw. The court conducted a closed portion of the proceedings to make further inquiry, and then in addition, conducted an ex parte proceeding without the states present to inquire of the defendant regarding counsel. And with that concluded, now the defense has presented their argument in support of the motion. So at this time, the court will consider the objection from the state, noting that this was a shortened hearing, so the objection was filed yesterday, which I do find timely. I have read and considered the objection, and Ms. Blake, if you'd like to present argument in support of the objection, you can do that at this time.
Thank you, Your Honor. First of all, the state recognizes that this is a decision that is solely within the court's discretion. I think Idaho Criminal Rule 44.1 clearly outlines that. It does indicate that a motion to withdraw can be granted, or excuse me, may be granted by a court for good cause. The state also recognizes that the Sixth Amendment guarantees a defendant the right to counsel. There have been additional courts that have reviewed that and provided some additional interpretations, which includes a defendant's right to conflict-free counsel. The state is appreciative of the court conducting an inquiry today because case law also lays out that a trial court's failure to conduct an inquiry into any conflict may result in a reversal of a conviction down the road. Additionally, the onus is on an attorney seeking to withdraw to present sufficient facts to support the motion. I think from the state's perspective, we are a little confused today because we read the affidavit that was presented to the court. Most of our motion was in response to that. The court has in fact done the inquiry and answered most of the questions the state had, also unsealing the order from the January proceeding where the defendant had referenced that Mr. Daybell was found indigent. We now have reviewed the transcript of that, and that did answer some of the state's additional questions. One being that there was an actual finding of indigency. The reason that that's so important in this case is because the Idaho criminal rules outline if someone is charged with a capital offense and they're found to be indigent, I think the term they use is needy, but the equivalent, and they choose to hire counsel, they're allowed to do that. They can have private counsel of their choosing. However, if they opt to request the court appoint counsel, then there's certain requirements, and that includes having a capital qualified first chair attorney and a capital qualified second chair attorney to assist them in the proceedings. In addition to that, it flags some additional requirements that the public defenders have to comply with. And there are quite a few of them in that list that must be complied with. But again, if a defendant opts to have private counsel, I think they do so knowing that their private counsel would not have to comply with those, or at least their counsel should be advising them of that. But they could also choose to forego having private counsel once they're found indigent in order to allow capital qualified attorneys to be appointed. In the review of the proceedings from back in January, it appears that there was a request to have some additional counsel assist on the case, and that was made by Mr. Pryor with his client, Mr. Daybell, present. At that juncture, it looks like Mr. Pryor was advised that if he could find someone else to assist in the case, that there may be funds available to help pay for that second attorney. In later proceedings, it looks like the court revisited that issue when no other attorney made an appearance. And at some point in those proceedings, Mr. Daybell was asked and essentially waived his right to have capital qualified attorneys. He opted to stick with Mr. Pryor. What's frustrating for the state is back in January a year ago, both the defendant and Mr. Pryor were aware of the defendant's financial situation. They clearly presented it to the court for the finding of indigency. At that juncture, they also were well aware that there was no second chair helping on this matter. So here we are a year later, and for the first time, this issue is being brought up that, hey, I actually want to withdraw because I'm not going to get paid. I'd have to work 24/7 in order to be prepared for trial and still probably can't get everything done in time for trial. So we've got two issues within that motion. One, the not getting paid, and the second one, whether or not Mr. Pryor can be prepared for trial. The state tries to be cautious in interjecting ourselves too much when it comes to a defendant and their choice of counsel. However, I think the ethical rules and other rules mandate that prosecutors try to ensure that defendants have the right or are advised and actually have counsel representing them in proceedings. When we look at that requirement of the state, as well as some of the other factors the state has to consider, such as appellate issues, The state tries to be cognizant of those and do our best to avoid creating them. I think that's what the court has indicated here today. The real question is, at least for the state, the finances the state's staying out of, but the real question for the state is, can Mr. Pryor be effective at trial? The state doesn't want to redo a trial. We don't want to get through trial and then have an appellate issue that requires us to do that again. While the state is extremely frustrated that this is being filed so late, and we are frustrated for the citizens, we're frustrated for the victims in this case. If this motion's granted, the state fully recognizes it's going to cause a pretty significant delay. And now the victims' families have to wait that much longer. The state now has to absorb additional costs. It's frustrating. But in looking at the big picture, we also want to ensure that we don't have counsel that cannot be adequately prepared for trial. When I said the state was a little confused today, the reason for that confusion is I'm referencing what was said in the motion. What's been presented here in court today is very different. So we have conflicting statements from defense counsel at this point. The motion read as if counsel was indicating, I cannot be effective. If you make me stay on this case, I cannot be effective. The reason I say that is no person can work 24/7 on something. We all have to have time to sleep. We have to have time to do other things. So I know it's a phrase used a lot, but the reality is if working 24/7, Mr. Pryor cannot be prepared for trial, what he's indicating is he would be ineffective at trial. What he's presented today is no, I can be effective. The motion says I'm not going to get paid. I want off the case. Today what's being presented is no, I'm fine not getting paid. I'll stay on the case. So if Mr. Pryor's representations today are I'm okay not getting paid and I can be effective, I don't actually know why we're here today. This doesn't appear to be a true motion to withdraw. The concern for the state is we've had multiple continuances in this case. And I recognize there can be arguments back and forth as to who did what and who caused the continuance. But at the end of the day, a year ago, Mr. Pryor was fighting very hard to get a continuance. He filed multiple motions to get a severance. He was finally successful with those in around January of last year. Maybe it was February, but he ended up getting both a severance and a continuance. Got a year-long continuance. Again, last January, Mr. Daybell had been found indigent. They knew there wasn't a second chair. He's proceeded on the case for a year. He had the benefit of watching the co-defendant's trial. He knew exactly how long that trial was, was able to observe and see how many witnesses there were, should have had a very good idea of what the trial preparation was going to require at that juncture. So again, very frustrated that we're getting here. But we had that. The request was, I need a continuance to test the DNA. We get past the trial. I'm actually not going to test the DNA. The state recognizes that different tactical decisions can be made, but it was very frustrating that we ended up with a continuance and severance for something that never ended up getting tested. Now here we are again, a couple months. I think today is actually 2 months before we're supposed to start some trial proceedings. And we're hearing a motion again on a request to withdraw, where the representations today differ significantly from what was put in the affidavit in motion. So this does appear to be another attempt to simply get a continuance. So the state's position on this would be based on the representations today. It doesn't appear this is a motion to withdraw. And if Mr. Pryor's representations today are accurate, then I think the motion should be denied. The one question the state has that has not been answered directly to the state, and maybe the court has this information, is there were some conflicting things also represented about Mr. Daybell and his specific position on this. In the affidavit, it indicated he did not want Mr. Pryor to remain on the case, that he wanted to have capital qualified attorneys appointed, that he didn't feel it was fair Mr. Pryor wasn't getting paid. Today, at least from the state's understanding, is we're hearing that Mr. Daybell does in fact want Mr. Pryor to get paid, so he wants him off the case. But then we're also hearing that Mr. Daybell would like Mr. Pryor to stay on the case. And I think that's really the important question today for the state is, does Mr. Daybell in fact want Mr. Pryor removed from the case? He's hired as private counsel. Is he in fact requesting Mr. Pryor be removed to have capital qualified counsel appointed? Because I think that's a different analysis and a different scenario than an attorney asking to be removed. So the state does not know the answer to that. I think
Ms. Blake, I want to be careful because I had an ex parte proceeding, but in general terms, I think it's appropriate for me to advise the state that Mr. Daybell does desire to have Mr. Pryor continue in the case. And as you mentioned, is also very concerned and does not want him obligated to essentially work for free. So that's his overall position in general terms.
And I think that's where we kind of run into an issue. While he may not want him to work for free, Mr. Pryor was hired privately. If a person has the resources to hire private counsel, or if a private attorney decides to stay on pro bono, I think that's the counsel and the defendant's choice. I don't think there's any avenue to allow Mr. Pryor to be paid through another mechanism. I also don't think there's a mechanism that allows a public defender to be appointed to assist Mr. Pryor. I think under the statute, it's if you're indigent and you're asking for counsel, you get a first chair and a second chair qualified appointed. I don't think under the statutes and the criminal rules, I don't see any hybrid system allowed. So I guess the state's concern is if that's the position of both the defendant and counsel, then we should simply be proceeding to trial and this motion should be denied. It's not a true motion to withdraw. If Mr. Pryor is saying I can't be prepared for trial in April, the state's very frustrated that this is clearly just a veiled motion to continue with a different title attached to it. Because that appears to be the true argument today is I need more time. So the state's very frustrated with that. Mr. Pryor's already had a year continuance. I guess from the state's perspective, if Mr. Pryor is going to stay on, we're headed to trial in April. The state's ready to move forward. If Mr. Pryor is saying I can't be effective at that point, then I think capital qualified counsel should be appointed and we should move forward with that counsel appointed and selecting a new trial date. But I don't think Mr. Pryor should be granted a continuance if that's really what's being sought today, and that's what it truly sounds like is being requested.
All right, thank you for
Thank
the argument and response, Mr.
Judge,
Blake.
can I respond?
Oh,
I was going to allow you a response, Mr. Pryor, so go ahead.
he just
Judge, I don't think I've been inconsistent in my representations in my declaration and what was said today. This court took the time to inquire of Mr. Daybell, and I believe what Mr. Daybell related to the court is consistent with what was put in the declaration. The reality of it is this, is that I disagree with counsel, and I don't know what she's reading or how she's interpreting a statute, but this court entered an order allowing the assistance of a second counsel to help in the preparation of this case, and did it some time ago. The reality, Judge, is that although I've made a strong and diligent effort to find co-counsel to help me in this, it's been difficult, and I haven't been able to accomplish that. And the reality is Mr. Daybell recognizes where we are in this thing and what needs to be done in the future. I don't have the benefit of Fremont and Madison County with their 5 attorneys in their prosecutor's office having free reign to do what they want at government expense. And the fact that both of those prosecutors then, in addition to their 5 state attorneys, sought out an attorney from Missouri and at county expense and on the county dime brought an attorney to work on a case that wasn't a death penalty case for the taxpayers of Fremont and Madison County to pay for that attorney, even though it wasn't a death penalty case. And that attorney is still on and still going in this case. And they've expended a significant amount of money. And I suspect it's not at the hourly rate that a prosecuting attorney makes in Fremont and Madison County. I suspect it's significantly higher. And for me to suggest that it's difficult with their 6 attorneys that they're working on this case, and I have to do this by myself, and the court recognized the
You've been on a
workload.
case for 2.5 years by yourself, and
I have.
all these attorneys, and the state carries the burden at trial, and they can prosecute a case they want. I completely agree with the state's position. The timing here, 2 months before trial is going to start, none of this is new at all. The charges have not changed since the indictment. The co-defendant went through an entire trial, which you observed and knew how long it would take. We talked about this concern a year ago, and here we are on the doorstep of trial, essentially. And the argument that is not persuasive at all to me is you're just learning now how much work it's going to take. Experienced attorneys, which you are, figure out how long cases are going to take, and you pick and choose the cases you decide to take as a private attorney. And this argument that they have more attorneys than you, they do. That's what they've elected to do. And you've also elected voluntarily, as has Mr. Daybell, to come on this case and represent him. And you've represented him since the beginning, and in fact, even since before this case began.
And Judge, the issue also is that I per my representation earlier, is that in 2022, I started seeking out assistance and additional counsel. And I made a diligent effort. In fact, I took the extra step of seeking counsel who were death penalty qualified out of the state, out-of-state attorneys. I then tried to find attorneys on the Public Defender Commission list and made a diligent effort. And then when I found one, I believe in October of last year, my expectation is that he would have been on this case by now. But then we come into late December and I'm finding out that he hasn't been approved or put on the list, even though the court authorized the funds, and I'm in this position. As I've said before, Judge, it's not a matter of being ineffective. And for the prosecutor to sort of hint at the fact that I've been ineffective, I would remind the prosecuting attorney that the fact is that, and I don't want to rehash this, but any continuance was the result of them not turning over a lot of evidence, and a lot of evidence that I ended up having to go through and make a determination. So they can't put any continuance on me when it was their own issue in terms of the discovery. The other issues, Judge, are simply this, is that having made that effort to find these attorneys and help me with this case, I recognized that back in 2022. But being able to find someone is a whole different story. And the reality of it is this, is that I'm not making differing statements from what I said today and what I put in that declaration. I've spent a portion of my life representing Mr. Daybell, and I would like to have continued that. But he sees the effort that needs to be go forward. And my expectation was in December or November of last year, I would have had an attorney on by now to assist me in this, and that hasn't taken place. And under our current law and the way the law is written and the way the court has interpreted the law, the only way for me to get another attorney and to have Mr. Daybell have the 2 attorneys that he wants, and what it was said in that declaration and what is said today is still consistent. The only way to do that is for me to make the decision to step away from this thing. And to step away from this thing would guarantee and require Mr. Daybell to have 2 additional attorneys. Is it something I enjoy or want to do? No. Mr. Daybell knows full aware how I feel about this case and how I wanted to be involved in this case. There has not been any differing representations to this court. The problem is this, and I recognized, you know what, they get to gauge how many attorneys they want. They get to gauge the amount of money they spend. And in terms of getting assistance for a defendant, I'm bound by the rules and the way the rules are written by our state legislature, and I'm bound by the statutes. And being bound by those statutes, I have no choice. If Mr. Daybell's going to, get the trial that he deserves, either I find someone to help me, which I did starting in with this court in January, but well before that, and to no avail, or I have to make the difficult choice. And I understand it's 2 months before this trial. I understand that. And it's not a choice I want to make. It's not a decision that I want to make in this case. But that overriding want for me to stay on this case, or that need for me to stay on this case, is overridden by the fact that Mr. Daybell should get 2 attorneys to help him with this. I would have liked to have been one of those, but there's no mechanism to do that. So any suggestion that I've been ineffective is ridiculous. This case was severed. This case was transferred to Ada County, and Mr. Daybell would agree with me that I've done everything to strongly and effectively represent him in this case, and he is completely satisfied with what I've done. But there needs to be additional help. And unfortunately, under our current statutes, I don't get that if I remain on this case.
Your Honor, I just wanted to clarify one thing so we have a clear record.
Go ahead.
The state has in no way insinuated or represented that we believe Mr. Pryor has been ineffective. What we were referencing is based on the affidavit written to the court that we felt that was what was being indicated is if forced to proceed to trial, he would be ineffective because he simply didn't have adequate time to finish his preparations for trial. So I want to make very clear, we are not saying Mr. Pryor was ineffective. I want that very clear for the record.
I understand that, Ms. Blake, and I agree. The arguments have not been any ineffective assistance of counsel. The arguments have been related more towards going forward in the demands of a 2+ month trial, and whether, given the concerns raised by the defense, a single attorney, that being Mr. Pryor, would be capable of providing all of the defense necessary for Mr. Daybell in this case. So That will conclude submission of argument on the motion. I'm going to take a brief recess, review a few things, and then I'll come back on the record to make a ruling on your motion shortly.
All right.
Ooh. Okay, so now this will be fairly quick, I would think, because we don't have to wait for John to yap at the judge. Let's go back. That's very sweet. Mimi says, let's support It's a Crime by hitting the like button. Thank you. Hit subscribe too if you're new. So this was good because Lindsay Blake comes in firing like, no. Like, this is ridiculous. She says, I'm a little confused today. She says she went through the transcript, and that was from a year ago, January, that they claimed that Chad was indigent. So she was saying like, well, what the heck? It's been a year. You knew that. Now, it's the same as what we were talking earlier, right? You knew that. So why is this happening now, 2 months before trial? She said, then she said something about Chad waiving his right for a death penalty lawyer and opted for Pryor. And she says they're well aware of the situation. Here we are a year later and not prepared. And she says, the question is, can Mr. Pryor be effective in trial? She said, we're frustrated that it's so late that in the game that he's doing this. It's late for the victims if this is going to happen and he withdraws, and the family has to wait longer. And don't forget, Lori and Chad's trial were supposed to be together once upon a time. And that would have been, the prosecution, Rob and Lindsay fought. They said, what about the families that have to travel and then spend another, double duty, not only for the money for the courts, but also the time that the families have to travel, and they take 2.5 months out of their life times 2. And they fought to keep it the same. No. John push. They got it severed. And now she's like, here we are again. And then it's pushing for the families. And she says, not only that, it's going to cost more for the state. She says, I'm confused. What was said was conflicting statements. And it is. We heard him say this morning that he wants to be on the case, yet his motion says he doesn't. Like, get it together, right? But obviously he has something up his sleeve. Otherwise, why would he do that? You don't usually see, I don't know if John has contradicted a lot. I mean, maybe he does too, but not like to this degree, I guess. He looks like he has 2 personalities. One is like, well, yesterday you said this, today you don't, right? And she says, so Lindsay's like, look, no person can work 24/7. We know that. You got to eat, you got to sleep, you got to do all these other things. And, at first it says he doesn't want to get, he wants to get paid, but he doesn't care he has to get paid. And she says, this appears not to be a true motion to withdraw. So she's seeing the tactics that Mr. Pryor made, and they see him do all this all the time, right? She said that he observed the trial for Lori. He fought hard to get the severance and a continuance, which he did. And then in Lori's, it was about the DNA test because there was a DNA test on her hair strand. Was that the one, or was that another one that they didn't talk about? It might have been her hair strand because they found a hair strand that belonged to Lori that was from the bag from JJ. However, there was another DNA test, I believe. And it was last year, it was all about the DNA test. And then they didn't have enough time, blah, blah, blah. John fought hard and they scrapped it, which was kind of a blow. But yeah, he didn't. Yeah, then it was talking about Chad didn't want the death penalty lawyers, and then went with Pryor. Today he wants off the case, but wants on the case. So Lindsay was reiterating that. And then judge is like, well, wait a minute. Chad Daybell wants to continue with John. But Pryor's like, I don't think I've been contradictory. Maybe you should review this later and then review your motion, and see what contradicts, buddy. Like, and I love where the judge is like, whoa, you've been on this case for 2.5 years. What are you talking about? He's like, none of this is new to you. He says that nothing's changed. Like there's no changes. You've observed Lori's trial. He said, here we are on the doorstep of trial, and now you're just, you're just learning about all this. He's like, he's not putting up with his BS. So I love somebody called him Crier Pryor. And then he was talking about ineffective counsel, and Lindsay's like, no, that's not what I said. I was talking about the motion. I wasn't talking about you. And Pryor says, either I find someone to help me, or I have to make the difficult choice, and it's not a decision I want to make. Well, then don't. He's like, he got his back up. Oh, ineffective is ridiculous. Chad is completely satisfied with what I've done. Okay. So we'll see what the judge says. What do you think he's going to come back with? This is exactly it, Rachel. This is what we were talking about. I talked about in the video the other day too. I'm confused why he's been working for free for a year and okay with it, but now he won't work for free. He can't stick it out for a few months. Exactly. You've been doing this for months, and now you're deciding now, and then you're whining that you don't have any help. And you should have memorized it. Okay, let's just put it this way. I've memorized quite a bit in the last couple years in this case, including dates and including things and all kinds of stuff. So if I can do it, then John can certainly do it. Right? Like, what do you need, John? What do you need? What do you need to know? You want a review about how the kids are in the pet cemetery? Honestly, like, I don't know. He's so full of it. And I love that the judge said, look, you were in trial watching, and Lindsay said that too. You were in trial of Lori's watching. You know what things are going to be laid out. So what do you need to prepare for now? It's been 2.5 years. Man. It's just like super annoying. So we'll see what the judge comes back. I think from what I see today, and correct me if I'm wrong, because you guys let me know what you think. I think that judge is going to come back and go, this is a load of hogwash. So I'm going to make you stay, and we're going to add some others. I don't know what he could do, but you could see this is a load of BS today. It's not even, after watching it and watching Lindsay and watching John, I don't know. Lindsay did well this morning. Can't wait for her in trial. And Rob Wood. Let's rename him Richard Pryor because he's hilarious. Carolyn says the trial itself will take a year if Pryor is still there. I know. And they said it's going to be longer for Chad's than Lori's. So Lori's was, I think it was about 8 weeks. So for Chad, I'd like to go down for that. Although I can't go the full, but I'd be there at the end. Side note, you want to see when I was cold in minus 46 what I wore? A full-on hoodie blanket that my oldest son bought me for my birthday last year. Because it's cold. I have a blanket right now too. It's not warm. Well, it's hard. In one, Connie says, no, the judge can't want him to stay. Yes and no, because this could mean, like, I don't know, a year, 2 years? Could it be 2 years that they're going to need as much time as possible? A year? I don't know. It's certainly not going to be in April if John gets off the case. So he has a decision to make, but I think the shenanigans today from John reneges on his motion last week. I think it's gonna wash it, so to speak. I don't know. Obviously, this is guessing. I'm guesstimating. Yeah, what was Pryor doing this entire time? Really, he was focusing on all his motions and hoping not to do any work. I don't know. I mean, he did go. Perry Mason would have done it in half that. Recap. Okay, where are we? So, we're on a break right now. John did the motion to withdraw. They're in court today to talk about it. John's contradicting his motion. Lindsay's saying, oh, hell no. You're not going to pull that right now. You should have done that a long time ago. And so John's like, what are you talking about? I'm not contradicting myself, even though in his motion to withdraw, he's saying, Chad's indigent. I don't want to work for free, and it's going to take a lot of time, and I'm going to just work all around the clock for the next 4 months. And also, I'm trying to get a guy who is death penalty qualified. He said he'll do it, and he should be shortly qualified. Now he's saying, guy's not qualified. He hasn't been qualified yet. We're still waiting. I want to get paid. And I don't care that I work for free also. And I want off the case, but I don't want off the case. So maybe you should take a little more time to yourself, touch some grass, ground yourself, and come back and tell us what you want. You know? Hopefully I recapped that well, and that's the gist of it. And I get it. I get wanting to be paid. I get that. And I get that Chad has rights to have a proper trial. So nobody's disputing that. We're just disputing that John's a little bit of a, an I was going to call him an idiot. I wouldn't say he's an idiot. But John's being a dumbass right now. Let's just say that. And I didn't think it would be that contradictory, but seeing that's definitely, there's a ploy, there's something. I wonder what his conversation with Chad's like. Just trust me, man. Like, we're going to go like this, and we're going to see what we could do. I don't know. So, but I think Judge Boyce will come back before noon. It's 11:39 my time and Idaho time. And I think he'll come back from noon because he's like, I really am hungry. And John has been talking and talking and talking. Oh, we just want to have a lunch break. You're so sweet, Mimi. Thank you. Thank you for being here. Thank you for being here for so long too. I appreciate it. And what do you call it? Just lost the word. Moderating. Thank you. That's the word. Not often I forget my words. So that's basically the gist of everything. And I don't know, I'm speechless. I'm glad we're here to watch this together. And I probably will do maybe a catch-up video. We'll see. Because I know sometimes for some people love the live streams, and some people are like, I'd rather you just have like a short, concise little video. So we'll see. But I have a ton of videos in a list that I need to get done. So we'll see. Shirley says, Linda, you've made me laugh. I needed a good laugh, especially today. We all do, don't we? We need a laugh. I got to say, 2023, I'm glad it's behind in the rear view mirror because it could keep itself. 2023 was a very tough year for me, and I am so excited about 2024. I really am. I'm looking forward to this year because it was a rough one for me. It was really, really rough. So there's my stomach growling. I might take a little bit of a drink. Adrian says, hi, Linda. Do you think John and Chad are bros now? I think so. You got to wonder what their conversations are like. Honestly, that would to be a fly on the wall about that. Christine says, I have been here since you first started. I only follow you now. You're so sweet. Christine, I remember you from the very beginning. I always, when I look in the comments, I recognize a lot of people, and I try as much as possible to get in the comments all the time, every video, and answer as many as I can. That's my favorite part is you guys. And then also, the antics of Lori and Letitia, whatever. But yeah. And a couple of people have asked me about Justin Evans, and I've been thinking about him lots because it's been a few years now that he was killed. And there's no updates on it, but I feel like fighting. I feel like fighting for him a little more. I feel like I have more in me, and I feel like I need to out more things in his case after taking that little bit of time off. I don't forget about him at all. And yeah, so. Now, also, while we're waiting, you see my background here that you've seen for so long? Mama wants to change it. So if you have some ideas, you can email me at itsacrimeandashame@gmail.com or let me know below because it's time for a little bit of a change. So I'd like to do that too, but everything little by little. And let me know what you want to know what you want me to do in the Daybell case, because there's still so much to go. And Lori has her upcoming trial. I wouldn't say upcoming anymore. It's pushed out, but there is Brandon Boudreau we have to fight for, and Charles Vallow. I just did a Tammy Daybell series, and you got to watch. I mean, Tammy was posed the day she died. And that just disgusts the crap out of me. So basically, go look at that, because if you haven't already, check out that video. I've done a few videos, one on Chad recently as well. Alex there the night that Tammy was murdered? Check that out. And there'll be a playlist, right? It should be a playlist right in my channel. So yeah, I love watching these lives with you guys too. It's just, I really do. It's my favorite. Oh, random question. Am I still vegan? No, I'm not. I was vegan for 4 years. I felt great the first 3. The last year I didn't feel so great. So I have incorporated a little bit. I don't eat it every day. I don't eat meat every day, but I've incorporated it back, especially chicken, which I've seen some benefits since doing that. But yeah, I was 4 years vegan. Oh, you love the It's a Crime hands right here. Yeah. Yeah, we're good. Yes, I'm absolutely covering Lori's case in Arizona. I like to see these cases that I cover to the bitter end. I will go like to the end, no problem. So that goes for Brian Koberger, that goes for the Daybells, that goes for all of these cases. Like I like to see it to the end and watch them go to prison. Thank you very much. I do like to deep dive, and I always have, I don't know, something down a rabbit hole I'm going. So it does take me sometimes a little longer to get the videos out. I wish there was a process to make it faster. I had an assistant for the last year and a bit, but I don't anymore. I'm finding that my process is actually faster these last few weeks. So that's good, but I don't know how to get it faster. And especially because I deep dive and I don't want to just put a surface video, like I really want to connect things in that. So it's going to take some time. I don't know what the answer is. Marissa says, Pryor's wife, why didn't you load the dishwasher? Then the 10 million years later meme scrolls through the room. You would love to hear more on Justin Evans. Yeah, I feel like going back and talking about what really bothers me in the case. And yeah. Megan Boswell isn't until isn't until 2025. They pushed the case because she dropped her lawyer. So that's a ways from now, but I will see that through too. Scott says the issue is the trial needs to be by the book, especially with someone's life on the line. Pryor's not DP certified and should have been removed long ago. Yeah, so that's the question. Now I'm curious if you guys heard him say that he could be, but he just chose not to or something. I want to know more about that. Yeah, goodbye 2023. Agree. Yeah, my OGs were here when we had the yellow wall. The yellow wall with my black chair. Bruce says, anything on Suzanne Morphew case other than she was found a little while ago? Nothing yet. I wonder that there's been nothing that I know of. So hopefully we could get information on that because we'd like Bear to, go away too. Allegedly. He is a walking contradiction. He sure is. I love the brick wallpaper though, more plants in the back. Yeah, I need to change up something. I don't know. I need it. The picture frames will most likely stay. My one died, so I have to fix it and then load it. Oh. Here we go. See, 10 minutes to 12. He's hungry. I called it.
All right, we've confirmed the live stream's begun again. We are back on the record on KCR 2221-1623. The court has before it the defendant's counsel's motion to withdraw filed on January 11th. I've considered the motion along with the declaration in support of the motion. I've also considered the objection from the state. We conducted a hearing today where I heard argument from the counsel, Mr. Pryor, in support of the motion, the objection by Ms. Blake from the state. Also conducted a closed portion of proceedings and an ex parte inquiry of Mr. Daybell and Mr. Pryor. And I've taken all that into consideration in determining the ruling on the motion. The court first is governed by Idaho Criminal Rule 44.1, which under paragraph A talks about leave to withdraw. and I'll just quote that section, "No attorney may withdraw as an attorney of record for any defendant in any criminal action without first obtaining leave and order of the court on notice to the prosecuting attorney and the defendant, except as provided in this rule. Leave to withdraw as the attorney of record for a defendant may be granted by the court for good cause." So we've gone through the procedural steps to get here for this to be properly considered. The rule allows the court discretion where it indicates the court may allow for withdrawal, and then looking at the standard of for good cause. So the court will first note to clarify in this case, this is a capital case. Idaho does have a separate rule governing the appointment of attorneys who are on a roster that are considered qualified to represent counsel or represent defendants in capital cases. That's Criminal Rule 44.3. And importantly, that rule only applies when a defendant is represented by a public defender appointed by the court and does not apply when a private attorney is retained in the case. And also importantly, where the court made reference earlier to questions about the mitigation phase, if that were to occur in this case under Idaho Code 19-2515, an inquiry to Mr. Pryor. And I'll note, and Mr. Pryor has correctly pointed out, that the ABA guidelines do apply to public defenders. They are not necessarily required to be followed by private counsel. Private counsel under Idaho rules are allowed to take on a case, capital case, and those guidelines may or may not be elected to be followed by a private attorney. Mr. Pryor clearly is a private attorney in this case, has never been appointed or publicly paid for representation of Mr. Daybell. Mr. Daybell importantly does have the right under the Sixth Amendment of the Constitution to counsel, and included in that right is to have the counsel of his choice. And Mr. Daybell elected a very long time ago to have Mr. Pryor represent him in this case. In fact, Mr. Pryor has agreed to take the case and has represented Mr. Daybell not only through the initial stages of the case here where the indictment was returned, but also in a previous companion case, and for I think about 3.5 years now, has represented Mr. Daybell. The court then going back to consideration of the motion before the court. There's an issue here that's been raised by the state about the timing, and of course the court joins in that concern also. Mr. Daybell has been incarcerated since June 9th, 2020. We've got a trial scheduled in 2 months. Mr. Daybell's asserted his right to that trial, and although he has waived his right to a speedy trial, certainly this case has taken a long time to get to trial, and at some point, even with a waiver of speedy trial, the court has to consider the timeliness of a defendant in custody being granted their opportunity for a timely trial. That right also applies to the state, and the state's right to seek justice for victims, to seek a conviction if they believe they have the evidence to do that, and to not have to wait through unnecessary and unreasonable delays in bringing a case to trial. So the court has a duty to try to timely administer cases, and while the rules generally slow things down a lot, there are reasons for that, but at some point the court has to consider the timing here. That's the big issue with this motion, quite frankly, is that the motion, if granted, would absolutely require a continuance of the trial and not just a brief continuance, because what would occur if I grant this motion and Mr. Pryor withdraws from the case, then under Criminal Rule 44.3, the court is required to appoint 2 capital qualified public defenders, absent Mr. Daybell having some manner of, again, rehiring a private new attorney or getting one to do it pro bono. The issue there is Idaho has a sparse number of attorneys on that roster, and Idaho is currently experiencing a lot of cases that are already resulting in appointments of a lot of available attorneys. And quite frankly, I don't have any idea who would be appointed of the two. I don't have any idea when we could get them appointed. But what I do know is the trial would have to be vacated and would have to be continued, and I think likely for a long time, maybe a year, maybe even more. Because for new counsel to come in, start over from scratch on a complex case like this, not have any review of discovery or any preparation, they would have to reasonably request time to get prepared, which would have to be granted. Mr. Pryor was raising concerns about trying to get second counsel appointed, and I've tried to accommodate that, Mr. Pryor. We had a hearing, it was exactly a year ago, on January 19th of 2023, and talked about your concern. The way I interpreted Rule 44.3, while it doesn't really address a situation with a private attorney together with a public defender, I don't think the rule necessarily prohibits that either. And so I approved that you could have co-counsel if you could find someone, but of course, they would have to be on that approved roster because this is a capital case. I don't doubt that you've made a diligent effort to try to find co-counsel. That's clear to the court. I know we've addressed that over the course of the last year on numerous occasions, the status of whether or not someone was coming into the case. We're on the eve of trial and no one has come into the case. With that in mind, then, the court has to also look at the impact that could potentially have. If Mr. Pryor withdraws from the case, Mr. Daybell is required to start over, abandon an attorney-client relationship that's been ongoing for several years, start over with a brand new attorney-client relationship with someone that he doesn't know and we can't even tell him who that would be. And also with the delay, I find that that prejudices the defendant. I also would find that given all of the preparation and time that has gone into this trial setting, which has been scheduled out for a long time, made by both the court and obviously the state in being prepared and ready to go, that there should be a presumption that we maintain the trial date. So the two concerns here raised in the motion really are, number one, the fact that Mr. Pryor would not be able to obtain payment for his services. And the court does strongly consider that because attorneys work for their profession and it's important that they get paid, and it's a consideration. But that in and of itself does not, in my mind, rise to the level of good cause under the rule 44.1 to grant the withdrawal. The second, and I think more concerning issue, is some indication in the motion of Mr. Pryor indicating that it would be very difficult, if not impossible, to be adequately prepared for trial. That's what's set forth in the motion. However, upon argument here today also, Mr. Pryor has indicated that he has made steps. I don't find anything in the record that he's been ineffective in his assistance of Mr. Daybell's defense in the case. And so with the concerns today being brought up and addressed directly by the court, both in open and closed proceedings, I don't find any specific grounds indicating that Mr. Pryor has said he cannot and would not be ready and prepared to adequately defend his client, although it may be difficult and he apparently will not be able to be compensated. It's not in the record that it can't be done. And importantly also, Mr. Daybell has affirmed today he does intend and would like to keep Mr. Pryor as his attorney in this case. And finally, I'll note that in addressing these concerns at that hearing a year ago, there was a representation by Mr. Pryor who said directly to this court, and I'll quote what was said in the hearing, quote, "There's going to be no continuance because I'm asking to get out of this case. That will not happen." And the courts relied all along on those representations in getting this case scheduled. So in balancing all that out and looking at whether or not good cause has been demonstrated today, I do not find that there is good cause for withdrawal of counsel. And so under Criminal Rule 44.1, upon consideration of that standard, the court is going to deny your motion to withdraw Mr. Pryor. I will note that I've previously made an approval for a second chair. If one can and will join the case, then the court will permit that, and we'll go through the procedure to get that properly done. So that's not a foregone conclusion. Given the timeliness of the trial, I understand that may be difficult. However, we are where we are with this trial setting, and because of the proximity of trial and the necessity of a continuance, if this motion were granted, the court finds that the motion fails to demonstrate good cause under the rule. For that reason, the motion is going to be denied. And Mr. Pryor, you will continue to represent Mr. Daybell through these proceedings. That'll be the ruling on the motion today, and I'll note that we do have more hearings scheduled and coming up, including motions and a pretrial conference. So, Mr. Pryor, do you have any questions on my ruling?
No, Judge, thank you for your consideration.
All right, thank you. Ms. Blake, any questions on the court's ruling? All right, thanks everyone for your attendance. That will conclude today's proceedings. We'll be in recess.
All right.
Wonder what he's whispering to Chad.
If you want to talk about the agreement or anything.
Motion denied, Mr. Pryor. Looks like the game is on. So basically, the judge came out and he said, yeah, no. If I look back, this is what I see. And I don't see anything that says that you can't be ready. And Chad, you did say Chad wants you, and you said you want on. So what I'm going to see here is that the motion is denied to withdraw, and you previously talked about getting a second chair. So if we can, and you will, we'll permit you to do that and get the procedure done. And I love that he even quoted John. There's going to be no continuance, that will not happen. Well, here we go. So Chad gets to keep Mr. Pryor, Mr. Spaghetti, and John gets some help with his second chair, and April's a go, which means we can keep diving into Daybell. I had to make the joke, even as cringy as it was, I had to make the joke in my last video about being thrown a curveball, because Chad likes to talk about baseball because Charles got hit with a baseball bat. And so he likes to talk about baseball and a ballpark price. And so I had to throw in curveball. Tess Max says, thanks for covering this from the beginning. You are so welcome. Thank you for being here. Thanks for watching. Thanks for, thanks for all of you guys to hang out with me and watch this crazy trial / court hearings. But this is great. This is great news. We can get this going. He gets a second chair. No more whining. You know, there's going to be more motions. There's going to be a lot more motions before trial. But it looks like it's a go, so this is good. This is real. I think it's good. Families get to get this done sooner. The judge is like, listen, I've had enough of your crap for the last how many years I've had to listen to you, so I'm going to stop you right there. This is what was done. And who knows? Maybe this was just a little ploy for John. I don't know. But we're good. Mr. Spaghetti. I don't know. What else can we do? Now he still has Chad's house, so I think he's gonna wait till the trial's gonna be at its height and sell it. And then everybody will want to go look at it and whatever else. Who knows what's gonna happen? But I mean, if he were to do something like that, it might be then. Home run for the state. Sarah says, been here since day one. That's amazing. I love that. It's been four years and 2 months since I've been doing It's a Crime, which is crazy to me. Remember my cringy video with Chad or Chris Watts? I got so much flack for that, but I feel like that's not done either. Meaning for the way I feel about it. It's done, but Andrea says, I love your classy digs. You know I got to get that in there. I hope you can't hear my stomach too bad growling. That's so sweet, Bunny. Thank you. I really appreciate it. It has been a rough year for me. I'm so thankful to be here, and I'm thankful you guys are watching my videos. Sometimes it's a long while before I get another one, but I literally work every day getting these videos out, even if it takes longer. So we're going to have some deep dives coming up. We're going to have some theory videos coming up, and you'll have my updates, and then we'll do more things like this with the hearings. I think is good. Super appreciate all of you guys. There's my stomach. Welcome, Holler Girly. Yeah, we're going to be going through the trials, so there's lots coming up. I know, I'm going to go eat in a couple minutes. We're going to spend 2 more minutes and then we'll go. But let's just have a couple we have to revel in this moment that John didn't get his way, because John got a lot of things his way. He did. But now we just have to revel the moment a little bit. So now, what cases are you watching right now? What cases are you invested in right now? It's very sweet, Connie. Thank you. Isn't that crazy from the very beginning of my yellow chair? A lot has happened since then. So what will happen now is the judge said, you stay on the case, John. We're going to work on getting a second chair. So another person's going to come in and you're going to get help and this is going to be okay. And it's going to go forward. So now I wonder what other tactics John's going to do. He's going to file a bunch more motions, I'm sure, whatever he needs to do to make himself feel better. But this is a go. Okay, you guys have a few going on. I'm going to write some. Wow. How do I keep up, you guys? How do I keep up? Wow. You guys are all over, eh? And before I change my bag, that's crazy. John will be working hard. Yeah. Delphi, Quentin. Afraid to ask how my son is 9 and 21. I have a 21-year-old as well. Mal says, Linda, I'm from Utah. My sister-in-law knows Eric Richardson's father, and she's heard that Corey's mom's husbands have died in suspicious ways. Really? This is interesting. That's interesting. That Corey is something else. It's like Letitia and Lori all smacked together. Man, you guys are really all kinds of different cases, hey? Sometimes it's a little bit intimidating going to look at a new case because it's like, well, I have to learn all this stuff. So I try and do different things in the background, and I don't know. It's time. We just need time. Yeah, Corey is something else. I did an update. If you guys haven't seen that video, check it out because there's another poison found in Eric. So Corey Richardson's is going to be a you-know-what show. Yeah, there is a lot of cases. So we'll see what I can do, some deep dives, some other stuff. I'm trying to, trickle some other stuff in there. So thank you for joining me today. Thanks for hanging out. It's been a solid, well, I guess 2.5 hours that we've been hanging out. Yeah, 2.5 hours. And so I'm going to go and do some work this afternoon and prepare more videos. And we will kind of see what's going to happen in the Daybell case. And yeah. So have a really great day. Thanks for joining me. We'll do this a little more often, hopefully. And we will see you guys soon. If you have any specific cases that you'd like me to do or help me, I don't know. If you want me to do, just email me. Be sure to check out my other videos, comment. I'm in the comments, especially in the first hour, and I go every day in there. So I love hanging out with you guys. Thank you so much. And we are getting justice for Tylee, JJ, and Tammy. And looks like too bad, so sad, John Pryor. You can keep your spaghetti in your pot. See you soon. Thanks for the mods today. Bye, guys.